Okay, if you can hear me, then I think we can start this session. Once again, welcome back, everyone, to the final leg of the bootcamp. Today is day 3, and we'll be kicking off while the rest will find us on the way. So once again, a warm welcome. I know we've come a long way from day 1 to today, and I'm grateful to have you all here today. So with day 1, we were grounded in the principles of data protection and privacy. Day 2 sharpened our legal research and memorial writing skills. And then today we finally get to step into the courtroom itself and focus on how you present and argue your case. So over the next couple of hours, we'll cover the foundations of oral advocacy, courtroom etiquette and professionalism, and how to analyze a case and structure your oral arguments around it. We'll additionally look into similar aspects of how to handle judicial interventions on your feet. And finally, our facilitators will share more litigation techniques. So by the end of today, you should feel more confident to stand up and argue before a bench. So as we get started, we're going to follow the same setup as we had for the last 2 days. You know that drill. Keep your microphones on mute. Use that chat to share your comments and questions. And so with that, let's get straight into it. We'll get started into our first session, which will be led by Mr. David Casavante, our facilitator from yesterday's session. We are glad to have him back today. He'll walk us through the first module, the foundations of oral advocacy, and also take us through the courtroom etiquette and professionalism to set that tone for how we carry ourselves and present our arguments in court. So, Mr. Casavante, if you're ready, we can kickstart your session.
Yes, Michelle, I am ready. I want to confirm that you guys can hear me.
Yes, we can hear you.
Okay, great. So, could you put my slides up and the beginning of it?
Okay, give me a minute. Let me share the screen.
Okay. All right, as those are coming up, good afternoon, everyone. Yesterday was a very good time. We had a lot of important discussions, so I hope that today we can also build on that, on what we had yesterday. Yesterday we were looking mostly at the written case, right? So our focus was on research, argumentation, the memorial. So today we are going to shift, okay? We're going to shift gears completely. Today we are going to talk about finding your voice, okay? Finding your voice and the foundations of oral advocacy and courtroom etiquette, okay? So I hope that by the end of this session, you will know how to structure a presentation that persuades the bench, how to handle tough questions, how you can carry yourself in a way that a professional advocate or a mooter does, even on Zoom. So you need to understand something that when you step before a bench, you're going to be advocating for a client, for a group of people, for people who look up to you, and they basically come to court hoping that court is going to hear them out, and you're going to be their voice, okay? So the way you carry yourself, it should be in such a way that you're not prejudicing your clients, but then at the same time, you are assisting the court to do what it must do. So remember also that all lawyers are first and foremost officers of the court. Okay, so you're an officer of the court, which means that the court relies on your expertise and your submissions in order to make its decision. Okay, so that said, you must ensure that you carry yourself in a manner that is going to ultimately achieve the ends of justice. Okay, so in so doing, sometimes you may find, for example, that you have a quote unquote bad case. Okay, the person that you're defending or you're representing, the facts do not favor them in a certain way. What you need to do is not to justify the thing, but rather to find other ways in which you can highlight, the circumstances or something that is going to show in a way that this person, whatever they did, could be justified, okay, in a way or the other. And the beautiful thing is, privacy law always will give you, it will always give you a way out. It always gives you a manner in which you can advocate for even, an entity that seems to be very wayward. Okay, so let's go to the next slide, please. So today we are going to be looking at two things. Okay, first, the foundations of oral advocacy. So how do you move from a written memorial to a live spoken argument? And how do you read and respond to the bench? And then we are going to also look at courtroom etiquette and professionalism. So how do you conduct yourself? How do you dress up? What is decorum? What things do judges notice even when nobody mentions it out loud? I'll tell you something. From the years that I've been on the bench in these moot competitions, many times we can tell that a team is good even before they start speaking. Many times when you walk in, judges are human beings and they can get biased by things that you do, even if you do not realize that you're doing those things. So when you walk in and the judge looks at you and before you even start speaking, we can already kind of make some kind of preliminary assessment of how you're going to perform. So what the journey for being a good mooter oralist really starts before you even start speaking. So some people believe, oh no, once I start speaking, they are going to hear me. I'm going to show them. Yeah, by the time you start speaking, usually we already have some kind of impression about you. And whatever you say either confirms that impression or rebuts that impression. Okay? So, next slide, please. Let's start with a mindset shift. Okay? Your memorials, they earn you a right to be heard. Right? However, it takes a very different skill altogether when you stand up to speak, to make yourself stand out. Okay? So when you do your memorials and write your memorials, you're always going to be, you'll feel good. And sometimes we read your memorials and we are very happy. We are very excited to hear these submissions that are going to come from these people. They seem very well articulate and all of that. So when we read your memorials, the next thing is going to be, what now does this person have to offer? In terms of oral advocacy, what are they going to give? So some of you write very good memorials, but which you cannot defend. Okay, so your memorial is well written, it's polished, it's revised again and again until it is perfect. However, the hearing is the opposite. It is spoken. It is live, it is spoken. You have to respond to whatever the bench throws at you in real time. Okay. And that can sometimes disorient some teams. So today we are going to be mostly focusing on building that second skill, okay? The one where you can now convince a bench that that you're good. All right. Next slide, please. So let's look at the first module, right? The foundations of oral advocacy. What we are going to cover here is what an oral round actually demands of you. How do you structure a persuasive presentation? How do you read the bench? And how do you use your memorial as a guide rather than a script? And on this one, there's going to be quite some, we're going to spend a little bit of time on that because many mooters fail at that last bit. So spend some time on it, okay? All right, next slide, please. So what exactly are you being tested by in the oral rounds? Okay, so again, I'm going to base on the guidelines, the rules that govern this moot. Okay, and as I said, I'm using the last version of 2025. That's the last version that we have. So I'm going to base on that to sort of give you, because every moot tests a different thing. Okay. And this one also tests a different thing. There is a score sheet, okay, that each judge has, and they have to test you on a bunch of things. So for example, structure and analysis of issues, okay? Now, your structure and analysis, and I believe this is where most teams rise or fall. When you come to speak, most of you are going to have the same law. Most of you are going to have the same facts. Actually, all of you are going to have the same facts. Most of you are going to have the same law. You're not the only one who has read. You're not the one who has gone through the Malabo Protocol. You're not the only one who has read a general comment on the right to privacy. You're not the only one. Everyone here has actually, most have actually read these things. The difference between them and you is how you structure your presentation and how you analyze the key issues in front of you. By rule of thumb, never start your arguments with your weakest point. Your weakest point is the one that will attract the most number of questions, the one that you're least familiar with. Let it not be the first thing that you speak, because the moment you say it, that's it. That's it. Okay? They're going to ask you so many questions, and you waste your time trying to answer those questions. Okay? Then, use of facts and legal principles. Okay, we need to know that you actually know the facts and that you actually apply those facts to the principles that are in front of you. Okay? Then, use of authorities and citations. This is important. You are not the law. You are not the law. If you say anything and the thing that you said will attract a question like, how do you know that? Or who said that? Basically, if you say anything which would attract a question in Luganda or Bijawa, okay? In English, that would be, where do you get this from? If there is such a question that would be asked of you, then the thing that you've said needs to be properly cited. When you come to court, you are not the expert. You are an advocate who knows a thing or two about the case that you're arguing, but you're not the expert. There are experts. They're called judges. They're called jurists, okay, who have written about these things, who have decided cases about these things. Cite the experts, okay? Then you have persuasiveness, logic, and reasoning. This becomes very key, especially when you're being asked questions, okay? Sometimes this may also be called ingenuity. How well do you think on your feet? Because remember, you're going to be standing there and you're not really going to be having a lot to go by. So you'll be saying one thing and then they ask you a question in another. How well do you stand on your principles and how well do you argue the thing that you're saying? Can you persuade the court that the position you're taking is the correct position? If the court asks you a question, can you reason with the judges? Can you show them logically the logical flow from your argument to the conclusion that you're trying to make? Okay? And then you have courtroom etiquette. This is a big one. This is a big one because many students, you get to court and then you start arguing with the judge. There is a moot I was judging and I asked a moot a question and they rolled their eyes. Well, they hoped I hadn't seen it, but too bad for them, I had seen it. They rolled their eyes and I was thinking, well, you've just lost points already just by doing that. You know, when you get to court, the judges are, depending on the court you're in, your excellencies, my lords. You know, would you roll your eyes at an excellency? Some of you get animated and you start banging. You bang the table because you're animated. You're so passionate about the thing. There was a moot I judged and someone was so passionate they left the podium. They started pacing around and we had to ask them to please to go at because we're in fear of our lives. You know, the fellow could be carrying a weapon and they wish to harm the judge. Yeah? So keep calm, be well composed, stay at the podium, speak from there. Things like gesticulating. Yeah? Some of you are good at making gestures. You speak and your arms are all over the place. They're this side, they're that side. You're pointing to things in the air and, you know, there was a moot again that we're judging and the mooter was gesturing so much with their hands, they did not even realize they were doing it. And one of my colleagues thought that the person was trying to give a middle finger to the court because their middle finger had stuck out for some reason when they were doing all this gesturing. And my colleague was offended. They thought that the fellow was abusing the court, you know. So those are things that you may want to be aware of and not be caught in contempt otherwise. Okay, but we are going to talk about that. So that last one, that etiquette, all right, it's worth exactly as much as your use of authorities, if you see, you know, and that's not a very small thing. So you're looking at a quarter of the points you're not putting into your legal argument. Okay, so how you conduct yourself in court is going to matter as much as the content that you're going to be giving the court. Okay, next slide, please. Right, so let's look at the order of pleadings and timing. All right, so this could be like your running order for every hearing, right? Usually we start with the first applicant, they speak, then the second applicant speaks, then the respondent speaks, respondent one, then respondent two, then rebuttal, then surrebuttal. Okay. If the matter is against the state in a national court, or even in some of the regional courts, sometimes the respondent who is representing the Attorney General is permitted to speak first. But their sole reason for speaking first is not to submit, but rather to introduce the participants, to introduce the bench to the participants. So all the Attorney General does is stand up, introduce themselves and whoever they are with, and then also introduce the counsel on the other side. Okay. And that's it, and probably announce what stage the case is on, and then sit down, and then the applicant will start their case. Okay, so that's just a matter of formality in some fora. Okay, you have up to 30 minutes per counsel, and any questions the bench asks you come out of that same 30 minutes. You don't get extra time. Okay, so try to be time conscious. Not keeping time can be taken to be some kind of contempt. Actually, in some moots that I've judged, if a participant went over and above the time, I would deduct a mark for etiquette. So those 30 minutes include everything, including your time for rebuttal. So you need to time yourselves very, very well. Okay? So rebuttal and rebuttal are usually shorter, up to 10 minutes each. But in this, you cannot introduce any new issues at that stage. You only respond to what has already been raised. Okay? You cannot introduce something new. Okay? So your time allocation has to be very precise. You have to be very, very, very keen on that. When your time is up, the right thing to do is to stop speaking. Regardless of you've been in the middle of your point, you wanted the court to know what you wanted to say. No, once you sit time up, you stop speaking. The judges will notice it, and if they're generous, they may allow you some extra time to finish your submission. But by all means, do not continue speaking once you see the time up placard. Just don't. You stop right then and there, and you can look at the judge. Some of you are very crafty. Once you see the time up, you start saying that my time is up, I would like to ask for more time. No. Oh, saying that my time is up, I want to conclude on this. No. Once your time is up, it's up. You stop speaking, you look at the judges. Okay? And they will tell you what to do next. If they're generous, they can give you additional time. If they are not, that's it. You go and take a seat. Okay? And even when the court grants you an exception, an extension, it's going to be capped at only 2 minutes. Okay? Some of you, I pray your excellencies, give me 5 more minutes to finish my point. You don't have 5 more minutes. Actually, for me, in my court, if someone asks for too much time, things like 5 more minutes, I tend to give them like 30 seconds. I'm like, hey, let's see. You ask for 5 minutes, you have 30 seconds. You know? So, yeah, so the court cannot grant more than 2 minutes to you. All right? And one more thing. Once you finish your main pleading, you can't add more. Okay? You can't add more. Even if you didn't use all your time, you do not carry your main pleadings into your rebuttal. And this is extremely important. Some of you do not finish all your pleadings within the time that you've been allocated, and then you sit there hoping that in the rebuttal, you're going to get them. Okay? When you come for rebuttal, that's when you start saying, in addition to what I said earlier, no, what are you adding? You had your time. Rebuttal is for only responding to what the other side has raised. Okay? Surrebuttal is when you respond to the rebuttal. You do not use your surrebuttal to respond to the, So surrebuttal is a response to the rebuttal. Okay? Yes, please. I think someone said something in there. All right, next slide, please. Right. So, how then do you structure a good and persuasive presentation? Okay. 4 things to build. All right. 1, always start with a roadmap. This is extremely important. Always start with the roadmap. Tell the bench exactly what you're going to argue and in what order that you're going to argue it. It's much easier for the judges to follow if they know where you're headed. So give the bench a roadmap of what you're going to argue and in what order you're going to argue it. I always say you tell the bench what you're going to argue it, and then remind them of what you've argued. Okay? Then always lead with your strongest issue. Some of you want to save your best point for the end. You forget that the attention of the judges is always sharpest at the beginning. So use that. Some of you want to save your best point at the end because you're used to, if you're served a plate of meat, you want to eat the meat last. Yeah? So you want to do that in court too. No, in court, eat the meat first. So come and tell the court your best points first. All right? And then you can deal with the problematic points, either as alternative arguments or in a different manner. Okay? Then state the rule, then apply it. Basically, we're back to IRAC. Okay? But this time in a compressed manner. Because you see, the bench has already read your memorial. Chances are we've already read your memorial. We do not need you to re-explain everything from scratch. Okay? So tell us the rule, then apply it. Okay? And then close every issue. Always have a conclusion to every issue. Some of you run away from issues as if someone is chasing you. You give an issue and then you run off. You do not conclude it. You do not, you don't make a conclusive remark. You just run away. Close every issue. Okay? And the whole presentation, usually with a clear ask. Okay? Tell the bench exactly what you want the bench to find or do. Having discussed this, Your Excellencies, we therefore invite this bench to find that the state violated. You get. Always give a clear ask at the end of each issue. Don't leave your issues hanging. And this applies to both issues and sub-issues. Okay? It applies to issues and sub-issues. Every time you finish a head of argument, give a brief conclusion on it. What exactly do you want the court to do with this information you've given it? Okay? That's how you would do it. Next slide, please. Now, you need to understand that the general rule, okay, is that your memorial is a guide. Okay? It's a guide. It's not a script. Some of you come with your memorials and then you start reading the thing. Like you're reading the first reading in church. No, we expect that you know your memory, that you know the things, you know the arguments that you wanted to bring up. We expect that you know that somewhere in your head. Okay? So when you come, you only explain the things that you already know. In fact, one of the signs that someone doesn't know what
Mr. Facilante, I think we've lost you.
Yeah, sorry. This went off and came back. Can you hear me now?
Yes, we can hear you.
Yes, sorry. I was saying that one of the signs that someone is a really bad mooter is when they come into court and they become a preacher, reading from their holy memorial. Okay? You are not a preacher, you're a lawyer. So explain the law to us. Okay? Do not read what you came with. In fact, Article 29 last year, Article 29 strictly prohibited reading a memorial verbatim during the hearing. Okay? So how do you avoid that? One, internalize your arguments. Internalize your arguments. Know the logic, not the exact sentences, but know the logic of what you're arguing. Use simple, short prompt cards. Actually, what I usually do, what I usually advise different teams to do, have like stick notes, okay, with simple key facts, authorities, figures, not an entire full paragraph, okay? Then practice, 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 and do it out loud. Practice out loud. Don't just read silently in your head. You practice out loud. Speaking is a very different skill from reading. Some of you guys are good readers, but you're very poor speakers. So speaking is a very different skill from reading. So practice reading out loud. Practice out loud. That way you can grow and hone your oratory skill, right? Now, what happens if you lose your grip under pressure? Questions have become questions. Life is not lifing. And the submission is not submitting. Go back to your roadmap. Remember that roadmap, go back to your roadmap. Okay? The roadmap will always get you back on track. Okay? So do not be afraid to go back to it. Right? Next slide, please. So let's then look at how you can read and respond to the bench. You need to understand that when you come to a courtroom, it's going to be a game of psychology. The bench is trying to read you, but you should also be trying to read the bench. Understand what the bench wants and then respond to it. Okay? There are going to be 4 habits that are going to help you make a real difference here. 1, always listen to the whole question before you answer. Okay? Listen to the whole question before you answer. Do not jump in halfway, assuming you know where it's going. By the way, it's an annoying thing. Sometimes you're asking a moot a question and then they assume where the question is going. There's even someone who was bold enough to tell me, I know what you want to say, my lord. I'm like, how? Are you in my head? Someone told me very boldly, I can get where you're going, my lord. I can understand where this is going, Your Excellency. No, you do not. You're not in my head. Let me first finish my question and then you can answer it. Actually, you can become an annoyance to the court instead of being helpful. Okay? Do not read the judge's mind for them. Let them ask the question so that you answer, you understand it. Okay? And where you do not understand it, you can ask for clarity. You can say, my lord, I I do not get what you're saying. Or, my lord, is your question asking this? Okay? Do not assume. Let the bench guide you. Okay? Now, when you're answering, answer directly first. Lead with a yes or no or your position. Then explain. Okay? Please do not be a meanderer. Eh? Some of you start speaking and then you start perambulating. The answer is here. You're going around, around, around. Why are you perambulating? Just answer the question. Actually, again, it can become annoying. And this is usually a problem for people who have overread. You've read a lot of things, you know a lot of things, and you're out here to impress the judge. You want the judge to know that, by the way, you know your thing, you read it. You want the judge to be properly assured. Friend, you're not impressing anyone. Hmm? You ask someone a question and then they cite 5 cases in one breath. My lord, that question was answered in case whatever. And oh, by the way, this case also talks about it. And by the way, this case also speak. Friend, you have not even told me what the case says. You're already telling me it's this case says this case, this case, this case. You're not trying to appease anyone. Okay? Just tell me, just give me one case. Actually, what I typically do is I will tell the agent, can you give me one case? Counsel, please give me one case. It should be enough. If you have to cite 5 cases for you to make a point, then yeah, you're not making a point. Okay? Always practice what we call Occam's razor. Occam's razor simply says that the simplest explanation is the most correct. Do not go around, and this also goes into use of legal terms. Some of you come with big words. You want the court to be impressed with your big words. You come with humongous, phantasmaglorious things. You're saying a lot of things. You're a forest of words, a desert of meaning. You are not communicating. If the bench is confused by what you're saying, you have already lost the case. We are confused. We are not following. Hmm? Some of you, before you come to court, you go and read the dictionary. You get a thesaurus and you find all sorts of fat words. Eh? Now you come and you start meandering with your big words. And we do not know what you're saying. Okay? So please keep the big words out that side. The best mooter is the best communicator. You need to communicate to the bench. What is communication? If you remember in primary school, if you studied communication, communication is the sending and receiving of messages. Simple. Sending, the message is coming from you. Receiving, the bench is going to receive it. Sending and receiving of message, that's communication. If you send a message and I do not receive it, you're not communicating. Okay? If you say something and I have a blank look on my face, you're not communicating. And by the way, some judges are proud. They're not going to ask you what that word means. So they're going to keep quiet and look at you and then deduct marks. You know, so please save yourself the trouble. From experience, I've noticed this usually comes from students who have a background in debating. So if you know that you're a debater, understand that you have an almost already existing predisposition to not communicating. You're used to quarreling, not communicating. In a moot, you are not quarreling. You are advocating. You are submitting, not quarreling. Please do not quarrel with the bench. Okay? Then, remember that the time that you spend answering bench questions is going to count within your speaking time. Okay? So plan for it. It's not a bonus round. It's not a bonus round. There is a mooter who had the audacity to tell me, Your Excellency, you asked me so many questions, so please give me 3 more minutes to finish my submission. I looked at them and I was like, so in your head, you didn't think you were going to be asked questions? Of course, you're going to be asked questions. You have to plan for it. It's not a bonus. Okay? So always put that within your speaking time. Right? And then stay composed under pressure. Court can be extremely pressurizing, but you need to understand, simply because the question is tough, it doesn't mean it's a personal attack. No, friends, the bench is not your enemy. We are only testing how strong your argument really is. This is an opportunity for you to shine, to show us how good you are. It's not a threat. There is a moot I was judging. I asked a question and the participants started crying. They started getting tears in their eyes. It's not an attack. We have to excuse the fellow. Do you need a moment to catch your breath? You know? And you see, this usually is going to happen to you if you haven't prepared. If you haven't prepared, they'll ask you a question and you start crying. Or you think that the judge has a personal vendetta against you. I've had these things before. Someone is asked questions, then when the moot is done, they go and they say, me, I saw that judge, though he was looking at me. Me, I knew that judge has a problem. Me, by the way, that judge went to this university. So that university has always hated our university. So that judge was out to kill me. Friend, first of all, we do not know you from Adam. When you come, we just see people in front of us. We do not know which universities you come from. We do not know where you come from. Nothing. So it is not personal. It is not personal. Just answer the question. Don't cry. Okay? If you cry, we will give you some time to go and compose yourself and then come back and answer the question that made you cry to begin with. So crying is not going to save you from the question. You'll still answer it, this time with dried tears. Okay? So try to stay composed. Okay? Maintain aura during the maintain aura. Questions are temporary. Aura is forever. Okay? Next slide, please. Okay. So in the moot, you're allowed to have one objection per session. Okay? An objection is only permissible in 3 situations. 1, a speaker refers to facts that are not in the case. Okay? i.e., they're saying something that's not in the case, so they have made up facts. Or there is a radical difference between what they're arguing now and what is in their memorial, because you're going to be receiving memorials of opposing teams. So if you find that there's a huge radical, not that they slightly diverted or they cited a different case than they cited in, no. There is a radical difference between what they say in their memorial and what they're arguing now. Okay? Or any other ground that the bench may consider appropriate. Okay? Now you need to be careful here. If the bench decides that you misused the objection, you can lose. You can lose up to 1 discretionary penalty score. Okay? But if you are right to raise it, then the other side speaker can lose a point instead. Now, usually from past competitions, we have never had a team raise an objection. So far, maybe if you want to be the first one, if you want to be the guinea pig to test whether you can, lose or, or gain a point, that's it. Okay. The good thing is that the time that you spend on the objection does not count against your speaking time. Okay. So that's the good thing. So you only get 1 objection per session. So make sure that you use it only and only when it genuinely matters. If it doesn't matter, some of you guys are just naturally argumentative. You're argumentative naturally from when you were young, when you were home. You were the one who was always quarreling at home. And so your parents said, this person is going to be a lawyer. The way they are over arguing, they're going to be a lawyer. So you set your eyes on that. You joined law school, not because you have a passion for the law, but rather because you're good at arguing. So you come to court and you assume you're also going to, some of you just have issues with everything. You see a thing and then you immediately want to argue over it. Friends, please make sure that you use these objections properly. If you misuse it, you will be penalized. Okay? Next slide, please. Okay? So, now let's go into the other aspect. Okay? Courtroom etiquette and professionalism. All right? Here we'll be looking at dress code, conduct during the hearing, communication rules, even in a virtual format, and the fair play standards that judges are going to expect from every participant. Okay, next slide, please. So let's start at the dress code. Okay. Last year, Article 8 set out the proper legal attire. Okay. So even if you're in a virtual session, in case it's a virtual session, you still have to present yourself properly on camera during the hearing. For men, a black formal coat, black, navy blue, the colors of the law, black, navy blue, or dark gray. There is a fellow that I was in a moot with who showed up in a pink suit with a flower on the side. Friends, the colors of lawyers when you're going to court, black suit. It's either black or it's navy blue or it's dark gray. Not sky blue. Okay? Not sky blue. Some of you wear suits that look like you are going on a wedding. Okay? There are those suits that have big collars that you wear on a wedding. Yeah? Someone showed up to court in a tuxedo because they were told you have to be smart for court. So they came to court in a suit that had a tail on it behind. Yeah? Needless to say, they did not have audience before the court. So again, court is not an opportunity for you to show off your your dress, yeah, your dress code, your nice suits, okay? Black formal coat, white shirt with a collar, black formal trousers, black formal shoes, and a black coat robe or gown, okay? Those are the things that will be expected. Yes, someone has actually even talked about the earrings. I was actually coming to those for the women. Also for the men, well, we do not expect you to have dangling earrings as a man. Why? Why do you have earrings as a man? Eh? Yes, we understand we are progressive and all, but please try to be as conservative as you can. For neckties, necktie color doesn't really matter per se, but try to be as conservative with the color as you possibly can be. It really doesn't matter as much as long as all the others are good. Okay? For the ladies, the same. Formal black coat, white shirt with a collar, formal black trousers, or black executive skirt, formal black shoes, and a black coat robe or gown. I need to give you a kind of for the ladies a bit of a warning specifically. So it can be black, it can be navy blue or dark gray. Okay, those are the colors that would be allowed. Okay. For the lady, someone has said your former CJ had a hearing. You see, the problem is you're not the CJ. You're not the CJ, so please try to not behave like the CJ. Otherwise, you bias the judges and you'll get problems. Okay. For the ladies, this is very important. Please try to avoid very heavy makeup. And this also goes to the hair that you choose to wear that day. Yeah, there's someone who showed up to court looking honestly like a drag queen. Okay, please do not wear makeup. Your face looks like a peacock. There's too many colors on your face, and then your hair looks like like a peacock. Please try to be conservative. Okay. Again, remember, impression matters. You do not want to show up in court looking like a clown and expect to be taken seriously. Okay? If you show up like a clown, we are going to treat you like a clown. And that's going to be to your own detriment. So please, ladies, this is a cautionary tale. This may also go to the men. I know there are some men who love makeup. Please do not be that man. Okay? Do not be that man. Of all things you choose to be, don't be that man. Okay? Next slide, please. Yes. So, how now do you communicate during the hearing? There are going to be 3 rules that we can gauge from Article 30 that may trip you up. 1, you're not allowed to coach mid-session. Okay? So any communication between speakers and coaches and other team members and spectators is strictly prohibited once the hearing starts. Only the people who are actually before the bench or the ones who are at the bar may speak to each other. And they only can do that without disrupting whoever is presenting. Okay? So, I have been in moots where someone was asked a question and their colleague stood up to answer it. I thought we were under attack. I was asking myself, why are you standing up? It was so abrupt and so out of the blue. Only the person who is currently speaking, who has been asked the question, can answer that question. Okay? If anyone wishes, if you wish to communicate when you're on the bench, do it through small chits, okay? And in some courtrooms, actually, you're not even allowed to communicate to the person speaking if you're not the one speaking. So someone may be submitting and you're on the bench and you want to speak to them, okay? That can be problematic, all right? The other thing that you need to take advantage of is you need to understand that you're not allowed to have devices. Some of you come to court with your laptop, your phone, your iPad. You're there and you're reading off your iPad. You think we are not going to see you. Yeah? We see you and we see the iPad and you will be penalized for it. Okay? Some of you now, you're very crafty. You come with your iPad so that you can Google the answers when you ask the question. You ask someone a question and they're like, 1 minute, my lord, 1 minute, my lord. Kumbe, the ChatGPT has frozen. It is not answering. We shall catch you. We shall catch you. My lord, I beg for 1 minute to answer your question. Why do you ask for 1 minute? Because you're asking ChatGPT and it has frozen. And you see the frustration on counsel's face. Because their thing is not working. So please desist and resist. Say no to the devil when you're coming to court. Please say no to the devil. That can be taken as cheating, plagiarism, which is punishable by sometimes even excommunication and discontinuation from the moot. So please say no to the devil. Okay? If you want, you cannot consult. Once you've started speaking, you cannot consult with anyone. So you cannot ask for 1 minute to consult with your co-counsel. No. Once you've started speaking, that's it. You're in it. If your co-counsel feels that the question they have asked you, you cannot answer it, what your co-counsel can do is they can take note of the question. When their time to speak comes, they can then answer the question. Your Excellencies, you asked my colleague this question. They may not have answered it to the satisfaction of this court. I pray that I elucidate on this question for the court. The court allows you, then you can answer the question. Okay, but you cannot say, let me first consult with counsel, and then you go back to ask them. They be asking you questions, and counsel is on ChatGPT because they are not the ones answering. They're at the bench. I mean, they're at the bar, so they're doing ChatGPT. So you say you're consulting, kumbe you're reading, what the ChatGPT has said. So, this is how we catch you. By the way, this is how we catch you. So, there are no exceptions to this. So if you break any of these, you're looking up to 2 penalty points being cut from you, and sometimes as many as 5 or even a discontinuation for serious violations. Okay? Next slide, please. Now, there are 2 rules that have very serious teeth. 1, recording. You may record your voice of your own team during your own presentation or the rebuttal, but you cannot record the opposing team during theirs. Okay? This is strictly forbidden. Okay? You will be immediately penalized. And this is extremely important because some of you, you think you're slick. You come to a session with your coach or some fellow from your university. So that fellow is seated behind there, and when the other team starts speaking, they stand up as if they want to take pictures. Kumbe, they are recording what the other team is saying. If you're caught doing so, your team will immediately be discontinued. Okay? And this also goes to the same thing as scouting. Scouting is when you attend a hearing you're not part of. Again, remember, you're in a privacy moot. You have to remember the privacy of your colleagues. Have they given you permission to record them? No, they have not. You're now a data collector who has not sought the consent, the informed consent, the prior informed consent of the data subject. Now here you are. You see how the things you're arguing are going to catch you. Yeah. Some of you, what you do is you come with a bunch of people from your university. You come with an entire bus. And then what you do is you tell different people to go in different sessions and listen to what the other people are saying. Then they'll come and give you a report. If you attend a hearing you're not part of, it is forbidden at all times. If your team friends from your university want to come and watch you, they can come and watch a session in which you are, but they cannot go to other sessions where your team is not participating. It doesn't matter whether they're just curious. It doesn't matter whether they're just trying to support their village mate who they saw on the other team, or their fiance or girlfriend or boyfriend, because some of you date across, universities. Okay? And you may be saying, my girlfriend is in the other university. I want to show support, emotional support, understanding boyfriend. Friends, no, you cannot do that. Okay? You will see her after the session. All right? And the penalty for scouting is actually disqualification. And it's final. So it's that serious. So please, the night before, explain to your girlfriend, explain to your boyfriend, explain to your boo, to your relative, to your village mate. Tell them, I will be unable to attend any sessions in which you are because I am forbidden from doing so. Okay? If they cannot understand you, you know what to do. That's grounds for a breakup. Next session, next slide, please. Okay. Yeah, someone has asked, once a question is presented by the judge, can the speaker ask leave of court for upcoming speaker to address the question? No. No. Yes and no. Okay. Yes, you can ask the court, but you have to do it in a very polite manner. So you can tell the court, your lordships or your excellencies, I thank you for the question. However, I feel like my colleague who is going to handle the next issue would be best placed to answer it. However, if this court would benefit from my simple analysis, this is what I can say. So you've let the court know that the question they've asked is directly related to something your colleague is going to say. Okay, and you're seeking the leave of the court for your colleague to say that thing. Okay, but you cannot tell the court, my lords, I cannot answer that question. My colleague is going to answer it. That would be contempt and you could be penalized for it. Okay, so you have to be very crafty and polite when you're seeking for that aspect. Okay. Then we have the rules of fair play and professional conduct, right? You are required to conduct yourself in fullest dignity and decorum, not just in the courtroom, but across the entire competition. Some of you, I remember there was a session that I have judged where someone, they had good submissions. They had good submissions, but when they got done, I think they got caught up in the moment. When they got done and their colleague was coming to respond, they cursed under their breath. They They use the F word. And unfortunately for them, the court caught it. You know? So you need to conduct yourself in a manner that is of decorum and dignity, not just in the courtroom, but also in the entire competition. Right? Right? A simple practice that you can do. You can exchange a handshake, okay, before and after every hearing. So when you come in, meet your colleagues, exchange a handshake, okay? Some of you are sour losers. When you feel like you've lost a round, you storm out of the courtroom. You're very pissed. You storm out. You don't want to talk to anyone. Please don't be a sour loser, okay? Just pay a simple handshake and move on. Such is life. It happens. Okay? Then your oral pleadings have to be your own effort as a team. Do not start getting outside scripts. Again, this is why we do not allow you to have your gadgets when you're submitting. Because some of you may be out there, you may be standing out, you may have in Uganda, we call them bachuba. A mercenary. You may have a mercenary out there who is busy sending you submissions and things to say. And that becomes a problem. That's why we cannot allow you to have your gadgets when you are there at the podium or even at the bench. So some of you are going to come with your AirPods. In your ears, there's some random fellow out there giving you instructions. No, the only things that are going to be allowed on your ears are hearing aids. Okay? And you should have a prescription for them, please. So you do not be getting outside help. Okay? Serious violations of fair play can lead to disqualification. Okay? So we need to make sure that the competition is free and it's fair for everyone. Okay? Next slide, please. So, quick reference. Let's make this really concrete. Some do's. Address the bench formally using whatever local convention applies. Remain visibly attentive when addressing the bench. Okay? Pause and yield immediately the moment a bench interjects, and thank the bench when you finish. Sometimes you may sometimes the judge in their wisdom may guide you that the point you're making is indefensible. Okay? And you try to argue around the defensibility, but it's an indefensible thing you're trying to say. Some of you can become callous in your submissions, especially the respondents. You can become callous and totally insensitive. You know, you're arguing about the rights of someone whose rights were violated, and someone will come and say the state has the right to do A, B, C, D, X, Y, Z, you know, in a very callous manner. And sometimes the bench will tell you, nope, the state doesn't. And then you insist, no, the state has to. You start quarreling. You have to be very, again, it goes back to, you know, decorum. You have to be very humble and carry yourself with dignity. Okay? Some don'ts. Don't interrupt opposing counsel or the bench. You know, the judge is asking a question, then you immediately interrupt them. Don't argue with the judge's ruling on an objection. If you raise an objection and the judge rules on that objection, please accept it and move on. Such is life. It happens. You don't always win. Okay? Do not read your memory or verbatim. Do not use devices and signals which the rules do not allow. None of this is complicated. It's exactly the kind of thing that is very easy to forget when you're nervous. So it's worth rehearsing. Okay? Rehearse, rehearse, rehearse. Okay? So that you do not get caught in the leopard's teeth. Right? Next slide, please. So, who is watching and why it matters? Each hearing is going to have at least 3 bench members, supported by a bench clerk who manages time and order. Okay? There will be different people, from the judges who scored your memorials. But the judges who will be there will have read your memorials, but they may not have scored them. So you're being assessed fresh against the same criteria by a new set of eyes. Okay? Judges have been encouraged to ask you questions during your presentation. Okay? That's why I told you these questions are not personal. We encourage to ask you questions. They want you to treat every single interjection you're going to get from the bench as part of the test. It's not an interruption. It's part of the test, and you'll be scored against it. Okay? Next slide, please. So, before you step into any hearing, run through this with your team. 1, do you know your roadmap well enough to state it in 2 sentences? Can you argue from prompt cards or short stick notes instead of a script? Have you rehearsed answering hostile questions out loud? Do you know which single objection, if any, might realistically arise? Does your attire meet the dress code, even on camera? Do you know the communication rules? Who can speak to whom and when? Have you actually thought through, the 15-point etiquette criterion we talked about, not just the legal argumentation? And are you ready and willing to thank the bench and your colleagues, win or lose? Again, some of you are sour losers. The moment you lose, you storm out, you become very bitter. You go and you start cursing the judge, you curse the bench, you curse everyone. Please desist and resist cursing the bench. We also have families to go back to. Your curse may work. Okay? If you look at all of these and you can say yes to all of them, then you're ready to walk into that courtroom with confidence. Okay? Next slide. All right? So, that's going to bring us to the end. The message that I want you to leave with is simple. Compose your argument carefully, then command the room when you deliver it. Both of these skills are going to matter, and now you need to have built both of them. Okay? So, thank you. It's been a pleasure working through this with you. I'll take any questions. Can a teammate respond to the question asked to the speaker? Yes, a teammate can, but not immediately. If a question has been asked from your colleague and you know the answer and you feel like your colleague did not answer it satisfactorily, when your time to speak comes, you raise and you inform the court, okay, that hey, you asked my colleague this question. I would like to guide the court on a response that would serve the court's better purposes, and then you answer that question. But you do not immediately say, "Hey, me teacher, let me answer that." No. You wait until it's your turn to speak, and then you can answer the question. Okay? Any other questions? Any other questions, comments, or concerns? Any other questions, comments, or concerns? Going once? Going twice? Okay, if there are no further questions, I think I can leave it here and leave my colleague to come and proceed with the next aspects. Is it better to answer questions politely and leave presentations? I'm not sure I understand that question. I'm not so sure I understand it. Anyway, I'll leave this to Michelle. Please. Hey, human, Bill Andrew, you have one. Please ask it. Hey, now I've been asking for questions you guys have not been asking. What if the judge in one way or another mislead the speaker? The judge cannot mislead you. It's an impossibility. The judge cannot mislead you because the understanding is you know your case so well. So if you feel like the judge is going in a different direction, it's always up to you to actually inform the judge of your position. Okay? So if the judge can ask a question or can make an assertion that you feel is not correct, you have to correct the judge in a polite manner. Okay? You can tell the judge, I understand what Your Excellency is asking. However, the applicant's submission is in fact this, okay, and it is based on this particular authority. While your submission or while your question is also valid, it is not it's not the submission of the applicant in this matter. Rather, what the applicant is saying is this. Okay. In the last moot, the presiding judge raised the point of correction on how to address the bench. He said you cannot address the bench as Your Excellency and not refer Your Excellency. No, this is again, I've been using different terminologies because different courts require different submissions. So some courts you're going to call the Lord, the bench, my lords or your lordship. Others, it's going to be your worship. Others, it's going to be your excellency. So I use all of these interchangeably, depending on the court that you're in. If I have 5 minutes only and I have 10 questions to answer, is it better to answer? Oh, yes, answer the questions, even if you have only 5 minutes. Please answer the questions, okay? This is a test of how good you can be, all right? So what you can do is you can categorize the questions into different categories. You say, Your Lordships, I'm going to answer question 1, 2, and 3 simultaneously because the answer is similar. So you answer them in a similar manner. But please try not to leave any questions unanswered. All right, if that's all, I'll leave this to Michelle to go ahead with the rest of the program. Thank you guys for your attention and good luck.
Thank you, Mr. Casavante, for that, for such a grounded and practical walkthrough. You've managed to give us a solid footing, both in how to build a persuasive oral argument and how advocates or lawyers are supposed to carry themselves. So let's keep the momentum going in with our next facilitator. We'll have Mr. Ahabwe next to take us through the next module. So once again, Mr. Ahabwe, welcome back. We are glad to have you here for this session today. Yes, over to you. I think you can take over.
Okay, good afternoon, members, and glad to be here. Thank you, Michelle, for the invitation again. It's always very difficult to speak after my very able colleague, Mr. David Kasivante, who I have most profound respect. So after his presentation, I will just be struggling, but I will do my best to just add something small to what he has said without diluting the contents of his general exposition of knowledge. So I'll turn off my video. I'm going to speak into case analysis, structuring of oral argument, something that my colleague has already said. So I will just be adding a little grain of salt. In terms of case analysis, yesterday I told you that each of you has been given an opportunity to participate in this moot. So I think the first thing is you need to know is what is this moot about? So number one, when you're given that set of moot problem, please read it. And I will begin by saying that is the case now. Read the set of those facts for the first time without any expectation. Read them as if you've picked a newspaper, right? And I know you've already maybe gone through them, but read them like you're reading a newspaper. Then the second time you read them, now read them with the intention and purpose to understand. Yeah. So the first time you're reading something, you're just reading it maybe to read it, but now read with a purpose to understand. I'm building on two case analysis. The second time, read to break each part or each aspect with an intention of extracting facts or what you'd ideally call relevant facts. So yesterday I gave you an example of the interception of Michelle's phone. So if you read the whole 50-page or 30-page document, but you're not extracting a relevant fact at the point where they are saying, this is when the phone was intercepted, or this is what they used to intercept the phone. That's a very important aspect. So what you're doing there is after you've read with an aspect to understand, you go on to read with an aspect with an intention of extracting the fact. So you start picking out. It doesn't matter if Michelle was holding an iPhone or not, but what happened to her phone is a relevant fact. I hope you're following there. That's part of case analysis. You extract the facts and then link them to the issues, because you remember yesterday we took you through on how to generate the issues. So it is very important that when you've understood the set of facts, because you will have to only apply the relevant facts. So you extract the relevant facts and marry them with the issues. And it's at that point that you're now generating the second aspect, which is identifying the law. So in simple terms, after you've extracted the facts and you're linking them to the issues, then you identify under what law each of those issues gets into. Then you marry the law with the issues. I hope you're following. So summarily, in case analysis, like I said, I will take just as an addition because a very able colleague has already done justice. Summarily, in terms of case analysis, please know what facts are relevant. Then break down what aspects bring or speak into the issues. So for every issue, you need to be knowing that there are 5 paragraphs in the moot problem that speak into the issue. So there are 5 aspects, 5 paragraphs. Those are the set of facts that speak into the issue. Then once you've done that, you need to know under what law you're proceeding. Once you've done that, you've been able to analyze the case. I implore you that for every paragraph you read in that moot problem, be able to identify at least 3-4 things that I've mentioned. What is the fact or relevant fact? What is the issue therein? What is the law? And how are you marrying the law with the facts? And then finally, how are you marrying the law with the issues at hand? Once you've done that, you've justiciably been able to do a case analysis. It's very, very important that you don't just read the facts, because when, like my colleague, Mr. Kasivante has intimated, when he's asking you a question, he will say, under what paragraph? So you need to know it is paragraph 15 that speaks into issue 1. It is paragraph 2 that speaks into issue 4. That will know that you have done a very clear case analysis. I think in terms of structuring the oral argument, which is the next thing, the thing you will notice there is, and like my colleague has said, what we usually, or what we will be looking out for in there, is about you being able to have that ability, yeah, to be able to, and maybe before I leave the aspect of case analysis, you will find that some teams struggle with extracting the relevant facts. So you must be able to separate what is proven and what is disputed. So you can find that what is proven is that there was a phone, Michelle's phone. But what is disputed is the nature within which it was intercepted. So it is very important that you make that separation. This will help you into able to be able to extract the facts. But then also yesterday we took you through on identifying what's the issue. We said that the issue should be able to speak into the facts. So what's the core is a very, very important thing. And then, like I told you, the law, yesterday we told you to apply things that are not relevant, not generally. So apply a precedent, apply a section that is most relevant. You will find that 5 sections can speak into the interception, but it is one that is direct to the breach. It's the one that you apply. And that is how you can be able to say that you have ably been able to do justice to case analysis. I think now I will turn to structuring of your oral arguments. Something that I think my colleague has equally very ably done justice to. You need a signposting. He called it a roadmap. You begin off by telling the judge what's the main goal. So you introduce yourself. May it please you, your lordships. My name is Michelle, lead counsel in this matter before the Honorable Court. And I appear with my colleague Peter, who together we've been accorded 20 minutes of this court's honorable time. And I will use 15 minutes to submit on one issue, and my colleague will use 20 minutes to submit on 2 and 3 and 4 issues, and thereafter make prayers. Your lordships, if there is no further indulgence, I would like now to give the roadmap to the issues at hand. I will be addressing the court on issue 1, and I will address it on 2 head averments. Firstly, that there was an interception of Michelle's phone. Secondly, that interception was illegal. And finally, that the court should hold that interception illegal and give justice to Michelle. So that's a kind of an example in terms of a roadmap. So you're opening to the judges and giving them, this is the goal, this is where I'm going, and you're signposting. So you go on when you're doing your signposting by clearly moving into your submission by saying, at this point, your lordships, I submit that section this of this has been violated. And you go on to continuously use those kind of extensive statements or furtherance statements during your submission. And those give you a weighted advancement into how you structure your arguments, rather than coming from wherever and then you're not concluding. Because if you use short phrases like I've given you of, your lordship, this concludes my submission on issue 1. I would like now to move to the issue 2, which concerns the aspect of the remedy at hand for Michelle. then that means that you've signposted, you're showing the judges, you've concluded issue one, and you're going on to the second issue. So signposting is a very important technique in structuring arguments, and you find that you don't waste a lot of time. The second thing I wanted to say is there are arguments you'll find that are very strong, and my colleague touched on this. So use your energy. Don't wait for, and he actually mentioned it. Some of you wait for the second strata of the argument. It's the one you want to use. No. Use the first argument to attack. Make mention of it and buttress it and say it's on that basis that we request the court find that there was a violation. So once you've done that, you've been able to structure your argument. And maybe before I leave signposting is that, and yesterday we talked about it, is that you'll find that people who have been able to give a roadmap, the judge follows through. So some of you, you come and you're mentioning your name, next thing you're going into the submission. Then I'm wondering, did he say he had a header varment? Did he not? Has he finished the first header varment? Is he going to the second? Is he going to the third? We tend to get lost. So roadmap gives you a clear view on where you're going, and it enables the judges to flow with you. And again, it's a conversation, guys. Some of you come and want to wrap. Some of you come and want to rush through. It's a conversation. So the better the strategy, the better the story is told. The second aspect I was asked this afternoon to speak to you is how do you handle judges' intervention, or what you would call interruption. Now, so many of you think that interruptions are very bad. No, most of them are very guiding. If you meet Justice Kasivante on the bench during this Moot this year, I hope he comes to judge. He has several interruptions on his bench. Yeah. But so many times you'll find that he's guiding the students. So number one is never at one point when you see the judge lifting up his lips, continue speaking. I implore you to use a pen. I implore you to use a sticker. Even if you don't write the judge's question, appear as though you're writing. That is the first technique on handling judge's intervention. Number two, if the question has been said, do you believe there was an interception? Don't start by saying, you see, my lord, under paragraph, use direct answers. Yeah. So before you go on to explain how you're going to dodge the question, just say, yes, your lordship were of the view, or the applicant submit that indeed there was an interception of Michelle's phone. And to this extent, we agree that there was a violation. Yeah. Then if you notice that the judge is indeed trying to pull you to himself and try to pull her to you to herself, don't argue with them. Yeah. So you can politely say, your lordship, whereas that might be true, yeah, we argue or we implore you, your lordship, to look at this direction in which the applicant is arguing. We implore you to look into this direction, because we also agree that this could have been done in this kind of a manner. So you move on the bench, yeah, not from your position. There's so many of you who come sticking. This is my argument. It has to win. No. So how you deal with the interventions is that you take on what you have been told, and then you advance. The second aspect is thinking, anticipating questions. I think this has been talked about. I think the bit where when I'm ending my submission, I'll tell you a bit of that, and I hope I don't forget. But any issue that you structure, please think through it with a minimum of about 5 to 10 questions that will be asked to you, and ensure that you have answers. Because the judges use that as a weak point. If you don't have an answer for the judge, that means you'll be caught off guard and you didn't prepare. So if you don't know something, two things can happen. You can say, respectfully, my lord, I have not addressed my mind to that decision, but in the alternative, I have also read this case which speaks into what you're asking, and use that and then move on. So that's a way in terms of how you interrupt with the judicial interventions. They can be several, but ensure that you don't get lost of your roadmap. The other thing I needed to make mention is that I Yeah. Then the other thing is as closing by saying that you need to be able to anticipate the questions. So please, 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 please don't be taken off guard and be able that you have the ability to respond to all the questions that have been put to you, because that is why the judges are there. And the questions are your friends, they're not your enemies. Yeah, they're not your enemies. The other aspect that maybe before I go to the litigation techniques is an aspect where my colleague again talked about distinguishing precedent. If the judge asks you a decision that you're aware was either appealed, you respectfully say, Your Lordship, that case dealt with this. And in the instant case, this decision or the case that I'm relying on is primarily in parliamentaria, or it is in sync with the facts at hand. Don't just say, for you, you have not read. You don't know these things. This current case does not address those things. So that is how you respectfully distinguish yourself from the others. Then it's very, very important that you use particular, I think I've talked about concession. This is what you don't know, please. It's very okay for you to say, I don't know, but in the alternative, I've read this. The other thing is, in terms of judicial interventions, please, like I've said, you act like you're writing, pen up something, drop the pen, and then respond. Your body language, don't yell at the judge. Yeah, be very calm. Like I said, it's a conversation. Respond with authority, but with a very low projected voice. And make sure your eye contact, you keep looking at the judge. Don't look down. I think my colleague has ably mentioned that. I will now turn into the litigation techniques, something that is very, very important. Because this speaks into what makes you unique. Yesterday we gave you the IRAC method. Yeah. So this is, again, like we've said, begin with the roadmap. It's a litigation tactic. Many of you have opening statements. Yeah, you can use them. Draft your opening statement. This case is about the violation of the human rights by intercepting the phone of Michelle. That becomes your opening statement. Then go on to signpost once you finish something. Then, so state the facts, define the legal problem, and then, like I've said, then go on to be able to marry the law. Now, they've told you of the phrases. Yeah. My colleague was very, very emphatic on this. Know the quote, it's my Lord, your Lordship, your Excellency, not Mr. Kasivante. You don't know these things. So be courteous. Yeah, be very courteous. It's a very highly technical litigation technique. You even speak. And I wanted to give you this technique when I used to motor in my law school days. I would say, thank you, Your Lordship, for that question. I see your question intimates this. And then, or I would say, thank you very much, President of the bench, Michelle, Your Excellency. So when you get sort of fond, yeah, you come up as very formal, but then you come off as very courteous and in sync with what the judge is trying to put across. The other aspect is, please be as slow as you can be. Like I said, it's a conversation. David will tell you that we've had scenarios where somebody comes and raps through their submission. Don't rap. You have all the time. You have all the time in the world. Yeah. So don't rap. You're there to ensure that you are as meticulous, as distinctive, as confident. Yeah. Yeah. And as agile as you can be. Think on your feet. It's a very key technique in litigation. You need to be having a case strategy. Yeah. So if you have an argument for issue one, what is the alternative argument? Some of you come with one direction. Yeah. So in terms of litigation argument, say, I'm going to argue like this, but if they ask me like this, I will answer like this. So have about 3 strategies of responses and walk through each of those strategies to ensure that when a question is bounced at you, you're able to answer. Then keep eye contact. Yeah. Do not come here and read a book. Litigation is not about reading. Everybody has read and understands privacy law. It is, you can even use sticky notes that they don't go with files. You can even come with just notes, yeah, or highlights of your arguments. Just don't come with every big thing. It's not needed. So come with very small things and then you'll be able to make a very good case. The other thing is once, especially this is for people who will be responding or respondents, once you've listened to the other side, be differential. Yeah. Like set out to say, having listened to what they said and respond, or begin by, if you're also the applicant, say, Your Lordship, there's a likelihood, but after you've made your case, begin by making your case and then say, Your Lordship, in this respect, we say that the phone of Michelle was intercepted. There's a likelihood, or the applicant might argue, yeah, and then you go on to make mention of what they might do, yeah. So I think having said that, I will go into, it's pretty much, I'm really but pressing what my colleague has been saying. The other thing I just needed to make mention of is a rule that I keep giving oralists during such a training is there are strategies in maintaining balance, or because when this is now litigation, you can be taken off. So it's very okay to pause and think. Don't rush through your answer. Yeah. Somebody is saying voice, please. I am very audible, I think. Michelle, can you confirm that I'm audible?
Peter, you're audible, but I think they want you to be louder than that.
Okay. Okay. I hope now I can be heard even louder. So I was saying,
yes, that's better.
Yeah, I was saying, please pause and think. Yeah. Do not rush through your answer. Yeah. It's a process. Yeah. It's not a sprint. Don't, it's a marathon. So silent is better. You find that sometimes you don't want to panic. Yeah. So my colleague has already shared that. So as a technique, pause and think for a minute. Yeah. Then sometimes if you ask the question that leads you into the second question, don't say, Your Lordship, that one I'll address it in. No, 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 no. You can actually politely say, Your Lordship, actually your question leads me to my second head averment, and I'll address it, then you'll go back. Yeah. So then what you don't know, please concede. Yeah. Then never make things up. I think Mr. Kasibante was very emphatic on this. The judges sometimes know these things better than you, sometimes. So you start lying, very, very, very punishable. Yeah, don't lie, don't lie. And then never speak over a judge. Yeah, it's a very good litigation strategy. And then once you notice that the judge is on your case, speak into his confidence. Yeah. Okay. I think now I will turn to the advanced oratory skills. And those are pretty much a summary of our discussion this afternoon. I think, like I said, number one is the thing that I was mentioning is be a high agency person. I don't know if you guys, you can Google what the meaning of that word. Be a high agency person as an oralist. Be very persuasive in your structuring. Don't mention things for the sake. Yeah. And then have a proactive response strategy, not one that is very static. No, proactive. Yeah. So summarily, number one is what's your roadmap? And your roadmap shouldn't take 10 hours. No, 2 minutes or 1 minute. I think my colleague Mr. Kaswante will tell you that we like roadmaps that are for 1 minute. Somebody will give a roadmap for 5 minutes. Once you've done that, be able to set out what you're going to say and say it very clearly. Yeah. Number 3, during the course of the explanation, Kristen, okay, so I was saying distinguishing the precedent. It's also an advanced aspect because you need to be able to distinguish what is former and then. Okay, I am not sure what Jeremiah was saying. I'm saying Jeremiah saying number 3. In terms again, please concede in terms of the advanced oratory skills. So drop something that you consider not to be. Okay, so I was speaking about conceding. So please concede to an argument that you don't know. It's very okay for you not to know something. Don't try to act like a god. And finally, I have uh, I've spoken about body language. Of course, I've talked about controlling your speed and pace during the speech. I will now run through the last and the very last basics that I will give you guys for that day. And these are the following. Number 1, once you've been able to identify cases, use quotes from those cases and attach them seamlessly into your roadmaps. Yeah. Like I said yesterday, you don't need to capture everything, but you can capture quote and it comes off very, very convincing. Then to build a very effective argumentative or argument, you need to be able to have 3 requirements of the structure of your speech. Number 1 is mention what you're telling the judge, then go on to say it, then conclude. That's a very important structure of structuring your effective argument. So this gives you an impression, and then this shows you that you're prepared. Number 2 or 3, to keep with the flow of your speech, please use linking phrases. This creates a continuation feeling, and then you have reasons to persuade the bench to a point where they feel that you're in sync with your speech and you're not all over the place. It's very, very important to use. Like I gave you an example. If you've concluded, you say, this concludes my speech. I will now turn to my third averment. So that's a linking phrase, which is very, very important to how you conclude. Okay. The other aspect, which my very able colleague Kasibante has talked about, anticipate questions. Some of you just come and you're mooting for the no. When you phrase the issue, be like, what are they likely to ask? That creates a difference. Yeah. So being able to craft those questions will make you differential from the rest. And don't just think of the question, but think of also the answer. Then, like I said, never think of a judge's interruption as irrelevant. Each interruption is relevant. Yeah. So it takes you somewhere, and the ideal way is to deal with it with the humblest way you can deal with it. Yeah. Okay. Then the other aspect is you need to be able to make the argument that wins the case first. So that's very important in structuring arguments. Don't begin with the last one. If the argument about interception is the one that wins you the moot, don't bring it last. Yeah. Use the most important argument. Okay. So, and we've talked about structuring the argument, having a summary of argument and then the overall. So, in the end, you come off very impressionable before the judges, you come off very prepared, and you don't come off as boring. Mr. David Casavante didn't tell you we don't want to be in sessions where somebody is talking to us and all they were doing is boring. You don't want to do that. Yeah. Then finally, give the judges a sense that you truly in sync with your matter, and in whatever way they were trying to take you off guard, you kept on the lookout. So conclusively, what do you take, or what should you take from these 4 or 3 aspects that, like I said, I'm really building because my colleague did justice? One, when you have an issue, what I want, this is about structuring your argument. What facts speak into your issue? I want you to do that. Look at all the set of facts you have. What facts? And by facts, I mean what paragraph, what line. Yeah. What law speaks into your issue? And by law, I mean primary law and secondary law. Yesterday, David took us through, and I also emphasized primary law being the statute law, and then the others. So you need to have all those under that. What are the likelihood questions I'm going to be asked on this issue? You can state them for yourself. 5 or 10 minimum. Then, what is your response to each of these issues? You know, this is a summary of what my presentation was about. What is your response to these issues? Yeah. And a response, I mean, you need to be having an answer which is legal, but also hypothetical in a sense that you're suggesting that that can work. You will find there are more problems where solutions are not set out right. Then what is your analysis and conclusion on that issue? That way, you will have mastered 3 things: case analysis, structuring your argument, handling judicial intervention, and becoming an advanced oratory speaker in the advanced moot stages. I'll spare the remaining minutes for interruption and interaction session, so that I really wanted us to interact more, question and answer. I would like to leave it at that, and unless there are questions, I am very much to take any, so that we can wrap it up. Over to you, Michelle.
As we come to the end of this session, do we have any questions or comments to be made towards this session?
Michelle, there's one in the chat, but I think it's to you, the administration. Somebody, Ronald, is saying you had promised to share a rectified copy of the moot problem, as the current one has some errors in numbering, and they're working on it, and we stick to the one we have. I think, Michelle, you'll respond to this.
Oh yes, regarding Ronald's query, we'll make communications regarding that in the group in the coming days. So Don't worry, that will be sorted. We'll communicate. Do we have any other questions, comments before we wrap this up? You could send it in the chat or raise your hand.
Advocates.
Charles, are you saying something? Okay, looks like there is nothing coming in from you guys. I'd like to wrap this up and to say with that, we bring day 3 and this year's privacy moot. Okay, Charles has a couple of questions. Let's first look at that.
Sorry. Sorry. Yeah. I just feel like
Charles, could you please communicate clearly or mute yourself? Peter, I think there's a question in that chat for you.
I think I've seen the question, but from Charles. Charles, you said where there's a repetition of the questions. No, you don't need to repeat your solutions. So again, like I said, be a high agency person. You can check out the meaning of that statement. It simply means that you think ahead. So you can say in a kind of a way that respectfully, Your Lordship, I'll answer your questions jointly. Or if it has been rephrased, you say, as I had earlier restated, but now with emphasis, Your Lordship, and you answer your questions. You don't need to repeat your solutions. Yeah, and I hope, Charles, that answers your question. You don't need to repeat the solutions. You just make mention of them, but with emphasis. Don't make it look like they didn't hear or what, but you mention with emphasis. Yeah, that's what makes you unique. I don't know what the rules this year are saying, Calvin, but we advised, and I think my colleague can also confirm, it's no problem to refer to regional statutes. Yes. Because that buttresses that you have read and you know. And I think last year they needed to show, or they needed a student to show that they have read Ugandan statute, they have read the Kenyan statute, and they have read the Tanzanian statute. So there is no problem with referring to it. I hope that answers your question, Calvin. Calvin, can you confirm that you've been assisted? But again, we encourage you and my colleague. I don't know what you mean, not really. What was the conclusion on the use of regional statutes? Calvin, I'm saying.
sir, maybe let me voice so that I can maybe be understood. My issue is not it.
Calvin, we've lost you.
Yes, I can't hear him. And maybe as Calvin gets the internet, for those that missed out, here is my email. Those who have questions, concerns, but you can also go through Michelle to see how we can continuously support you. The the organizers of this moot are the only people that I know on the nationally, but also regionally, who organize such a boot camp to assist. Other people I know, they send out the problem and you figure out life. So this is a unique avenue, and please, I thank them for such an opportunity. So please take advantage of it. If you have questions, concerns, and maybe form of guidance, I've shared my email, but reach out through Michelle, who will be able to assist. Even as Calvin's question, will be able to assist. Yeah, thank you. Over to you, Michelle.
Okay, thank you so much, Peter. It looks like Calvin has permanently fallen off the call. So with that, I would like to close this session. And I'd like to thank you all for participating in this bootcamp for the past 3 days. You've been such a genuine audience. And your engagement throughout this journey has been so rewarding. We are grateful for that. And to our facilitators, I really want to pause and say a genuine thank you to you, Mr. David, and Mr. Peter as well, and the previous facilitators we had over the past couple of days. I mean, technically the first day. So we really thank you for bringing your expertise and your energy, for pouring that into the past couple of days. What you've shared with us goes far beyond, the slides and the modules. It's that kind of knowledge that will really shape us into how to show up in the courtroom. So thank you. On behalf of Unwanted Witness, we're really thankful. And we thank you for being a part of this wonderful journey once again. And we wish you all the best of luck in the next stages of the competition. We cannot wait to see how far you will go. So I wish you all the best of luck, and have a great afternoon. So with that, I'd like to close this session.
Okay, thank you, Michelle. Cheers. Thank you, everyone. I've seen my very good friend and brother, Mr. Joel Basoga, was on the call. Very, very grateful. Thank you for always being present. And thank you to Unwanted Witness. And all the best to the mooters. Just count it as your opportunity to bring out the golden star in you. God bless you.